Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hi, everybody.
So we got a little sun across the country over the weekend, which was nice, and many of us got to see the Northern Lights. Did you see them, Dennis?
Well, disappointingly, no, I'm afraid I didn't. I was too busy watching the results come in for the Eurovision Song Contest on Saturday night.
Yes, that was rather exciting as well. Well, let's take a walk through the bulletin and beyond, Dennis. So what's your first highlight?
Well, Helen, this week's bulletin contains a raft of guidance concerning changes to homelessness decision-making, particularly in relation to those who have left care. There are new governance arrangements being introduced that set out in joint protocols that councils are required to develop. Here's some detail on all of this. The Secretary of State for Education, Gillian Keegan, and the Secretary of State for Levelling Up, Michael Gove, have written to local authorities setting out a three-step approach to reducing the number of care leavers found intentionally homeless. The first of these steps has seen DeLuc update the Homelessness Code of Guidance to strengthen the department's expectation that all local authorities should develop a joint protocol. The letter said, joint housing protocols codify the practice of joint working between children's and housing services that is essential to support care leaver transitions to independent living and accommodation. And housing authorities, children's services authorities, and other relevant departments within local authorities should have joint housing protocols and procedures in place so that each department can play a full role in providing integrated support to young people leaving care. And this should help children's services and housing authorities develop the local accommodation offer to care leavers and play a key role in preventing care leaver homelessness. The ministers added that the joint housing protocol should set out the commitments as corporate parents and how these will be delivered in practice. It should include commissioning of suitable accommodation and support for care leavers to reduce the risk of homelessness. And the department added that its updated good practice guidance could support local authorities with the development of these protocols. The second step set out in the letter is an expectation that intentional homelessness decisions for care leavers are to be exceptional. The Secretaries of State said, we expect that local authorities should avoid the impact of intentionally homeless decisions wherever possible. The Homelessness Code of Guidance is being updated to clarify that when a housing authority is considering whether a care leaver has become homeless intentionally, they should be satisfied that the support and accommodation provided has met the care leaver's needs. They say that while they recognise that in rare situations a decision of intentionality may be necessary where all other avenues have been exhausted, local authorities must have regard to care leavers' vulnerability and the lack of parental support and stability that would ordinarily be provided to young people when considering accountability. Intentional homeless decisions in respect of care leavers should therefore be exceptional. And the third and final step of the new approach is increasing governance around intentional homelessness decisions for care leavers. And there are significant changes to the approach to homelessness that will be of particular interest here to housing, social care and children lawyers. They represent the government's response to the recent care review, and they recognise the special status that ought to be given to young persons who have been in looked after environments at some point in time, and indicate the new governance that is required in the form of these new joint protocols to prevent issues concerning homelessness. All the detail is in the bulletin, Helen.
Well, sticking with letters from government, the Right Honourable Chris Philp, MP Minister for Crime, Policing and Fire, has written to the chairs of the police and crime panels outlining an amendment they tabled on the 9th of May to the Criminal Justice Bill to change the responsibility for handling non-serious complaints about police and crime commissioners to an independent person, they say, such as a local authority monitoring officer. Now, LLG have some concerns about this, and we're fortunate to have a brilliant MO and governance lead in the form of Helen Bradley, who succinctly outlined concerns as follows. Now, LLG has a general objection to the proposal without any meaningful or recent consultation with monitoring officers, or indeed consideration as to what this might mean or look like. Resources available to MOs to deal with such matters are increasingly stretched, and the requirement for MOs to determine complaints would be an additional burden that needs to be provided for. If the proposals are implemented, the Home Office grant provided for PCCs needs to be uplifted accordingly. Unlike other member conduct matters, MOs do not have the knowledge or expertise of policing matters to determine general complaints against the PCC. Almost all complaints involve or relate to matters of policing, which are outside the MO's knowledge, particularly where the complaint relates to the PCC's response to complaints against the Chief Constable. In order to prepare reports for the panel, additional inquiries would have to be made in relation to police complaints handling procedures. We consider that the Independent Office Police Conduct is the best place to judge these matters rather than monitoring officers. The outcomes available for panels: a complaint has been satisfactorily dealt with, or informal resolution, and the associated procedures are unnecessarily complicated, and in the majority of cases do not result in matters being resolved to the satisfaction of the parties. The potential outcomes do not meet with the expectations of members of the public who submit complaints. Panels are also often frustrated by the limited options available to them. LLG would support reform of the complaints process and suggest something more akin to arrangements for counsellors, such as a code of conduct and arrangements for dealing with breaches of the code. Monitoring officers can deal with complaints against elected members, but in the majority of cases, the most serious cases are referred to the Standards Committee to determine whether or not there has been a breach. It is therefore not appropriate for MOs to determine complaints against the PCC without any reference to panels. Again, we would submit that this is something the IOPC are already equipped to do. So LLG have made representations, and we wait to see how these are responded to by the government. Watch this space. Now, in a complete change, you have a question, I believe, Dennis.
Yeah, indeed I do, Helen. And it's this: when can negligent advice, or perhaps a misstatement, give rise to a duty upon a council not to cause psychiatric injury? Well, this issue was highlighted in the Law Society Gazette last week in a case concerning a taxi license. A rare case on the duty of a local authority not to cause psychiatric injury to a cab driver applying for a license has culminated in the authority obtaining a charging order on the driver's home. Wokingham Borough Council had negligently informed Mohammed Arshad that his hackney carriage would meet its policy for wheelchair-accessible vehicles, but a later inspection found that the second-hand Ford Galaxy did not meet those requirements, and the council sent Arshad a licence suspension notice. Arshad, who had held a hackney carriage licence since 2006, subsequently developed a depressive disorder and sued the council for psychiatric harm. He succeeded following a trial in 2021, and Deputy District Judge Lindsay awarded Arshad £42,500 in damages and costs. The council made an interim payment of £10,000, but then successfully appealed to the High Court on this issue of duty to avoid causing psychiatric harm. And in September 2022, Mr. Justice Bourne ruled that the suspension, though it threatened Mr. Arshad's livelihood, did not actually prevent Mr. Arshad from working. He drew a comparison to a Court of Appeal case of Yap and the Foreign and Commonwealth Office, which held that even a serious threat to a person's career by itself is not enough to establish a duty not to cause pure psychiatric harm. Mr. Justice Bourne concluded, "It seems to me that whilst any serious setback may be capable of causing a degree of psychiatric harm to anyone, psychiatric injury in this case was not so reasonably foreseeable as to make it appropriate for a local authority giving discretionary pre-application advice on a licensing matter to owe a duty of care not to cause pure psychiatric harm." Mr. Arshad was ordered to repay the interim payment of £10,000 by October 2022, but a hearing at Reading County Court last week revealed that he still had not paid the money, prompting the council to seek a charging order, which they successfully obtained. Now, of interest to us in all of this are the findings in the earlier Court of Appeal case on the duty issue, and the fact that a claim on this basis is unlikely to be sustained against a local authority. Helen.
Well, that definitely is a very interesting case, Dennis. Thank you. Now, the Best Value Standards and Intervention Statutory Guidance was amended following consultation, and that's been published on the 8th of May. Local authorities are now required to have regard to this guidance on best value standards and intervention. Now the government is consulting on the best value duty, and it seeks views on statutory guidance for local authorities, including combined authorities and combined county authorities in England on the best value duty. And it's, of course, issued to local authorities in England under Section 26 of the Local Government Act 1999. And authorities, of course, are required to have regard to this guidance under the 1999 Act. So what does it do? Well, it provides the government says it provides greater clarity to the local government sector on how to fulfil the best value duty by describing what constitutes best value, the standards expected by the department, and the models of intervention at the Secretary of State for levelling up housing and communities disposal in the event of failure to uphold these standards. I would urge everyone to take a look at the proposed guidance. I'm just going to flag up here the short section on OFLOG. So the guidance says OFLOG will provide an authoritative and accessible source of information about the performance and health of the local government sector. The department's best value analysis to inform judgments to inspect or intervene will be improved through OFLOG's objective to increase transparency of performance in the sector. Both OFLOG and the department are committed to high standards, which are frequently met by authorities, and to identify early indications of failure. To support this, alongside the publication of this guidance, the department is consulting on what indicators should be prioritised in informing engagement with authorities to ascertain compliance with the best value duty and what quantifiable metrics would be appropriate to consider. The standards and models for intervention set out in the guidance belong to the department, and the guidance may be updated as OFLOG's role continues to develop. Now, this is interesting, and bear in mind, we've spoken previously, I spoke last week about the metrics and the way in which the statistics have been published by OFLOG on their website. And more interesting is when you consider the fallout from the published Times article, where it listed what it considered to be the worst performing councils in a league table, which was extrapolated from the OFLOG data. Now, the MJ reports that some council chiefs were left in tears following the publication of that Times article, and the LGA was reported as saying the article would cause councils distress and expressed concerns the sector's trust and confidence in OFLOG had been shattered. Now, the LGA have written to the government to outline its concerns. I hate to say I told you so, Dennis, but it can't come as a surprise to anyone that this has happened. Now, thinking about the stress of working in local government, Dennis, in the current landscape, what can we do about well-being?
Interesting that you should ask, Helen, because from time to time we do cover well-being issues in the bulletin. And here I do want to raise an issue that was highlighted last week in an article in the Law Society Gazette, which I'll explain why I think it's important. It's the issue now known as digital burnout or exhaustion. Allow me to explain. In our complex, high-demand world where digital devices and online platforms are integral to both professional and personal life, the phenomenon of digital burnout has become increasingly prevalent. From working on a laptop to unwinding in front of a television or scrolling on your phone, spending too much time using screens has led to feelings of both physical and mental exhaustion. And according to an article in last week's Law Society Gazette, digital burnout, characterized by these feelings of exhaustion, detachment, and inefficacy, poses significant challenges to an individual's well-being and productivity. It is crucial to not only understand the causes and consequences of digital burnout, but also to implement effective strategies to mitigate its impact. Now, Helen and I will take a deep dive into this and discuss first what the main symptoms of digital exhaustion are, and then what you can do to avoid digital burnout and reduce the risk of digital fatigue and frustration. But first, what is digital burnout? Well, digital burnout refers to a state of mental, emotional, and physical exhaustion caused by prolonged and excessive use of digital technologies. It is characterized by feelings of being overwhelmed, of fatigue, disengagement, and a sense of being constantly plugged in or tethered to digital devices. One primary contributor is the constant accessibility and expectation for connectivity in today's society. The pervasive use of smartphones, social media platforms, and digital communication tools blurs the boundaries between work and leisure, leading to an always-on mentality. And as a result, individuals struggle to disengage from online platforms, leading to chronic stress and exhaustion. And moreover, the relentless flow of information and stimuli in the digital realm can overwhelm individuals' cognitive capacities, resulting in information overload. And the incessant notifications, emails, and social media updates bombard our senses, impeding our ability to focus, prioritize, and engage. And additionally, the pressure to maintain an online presence and project a curated image on social media platforms can exacerbate feelings of inadequacy and self-comparison, further contributing to burnout. Now, digital burnout is not just limited to any particular demography or age group and can affect individuals across various professions and lifestyles. It is increasingly prevalent in today's hyper-connected world, where technology plays an integral role in almost every aspect of daily life. So watch this week's vlog for more on this and the solutions for dealing with it. Helen.
Absolutely, we had a great discussion in the vlog this week. Now, finally from me, I want to take a look at the case of the King OAO TTT and the McKellar Community Schools Trust and Brent LBC, which examined the question, to what extent can schools and colleges ban pupils from taking part in prayer rituals on their premises without breaching their convention rights or discriminating against them? Now, the High Court has provided some useful legal guidance in this case. Just a bit of a background on the case. The claimant wished to pray specifically during her lunch break during the autumn-winter months because a particular prayer period falls at this time during her break, as she considered it to be her free time. The claimant argued that the school's refusal to permit her to do this was a breach of her right to freedom to manifest her religious beliefs, which is protected under Article 9 of the European Convention on Human Rights. Further, that it indirectly discriminated against Muslim pupils, contrary to sections 8.5, subsection 2D and or subsection F of the Equality Act 2010, when read with section 19, and that further the school failed to have due regards to the need to eliminate discrimination, to advance equality of opportunity, and to foster good relations between Muslims and non-Muslims, which is contrary to the public sector equality duty under section 149 of the 2010 Act. Now, there are other elements to this case, and it's quite complicated, but I'm going to focus on the core one, which I've just outlined. So the High Court rejected the claims for the following reasons. So one, in respect of right to manifest a religion or belief, the High Court said that people have an absolute right to believe in a religion or belief, but only a qualified right to manifest their religion or belief at a time of their choice. And courts will generally not uphold claims of a breach of this right where the claimant has voluntarily accepted rules which limit the way they can observe their religious beliefs, or there are ways to get around the limitation, or they have a genuine choice about manifesting their beliefs elsewhere. Now, on the indirect discrimination, the court said that the Equality Act prohibits discrimination in the provision of services, including the provision of education, and schools are prohibited from discriminating against a pupil on a number of grounds, including by subjecting them to a detriment. But it is possible for employers to justify their approach if they can demonstrate that the policy in question is a proportionate means of achieving a legitimate aim. And the judge found in favour of the school for the same reasons as set out under the Human Rights Challenge. And in respect of the public sector equality duty, Even though there was no specific reference to that in relevant briefings and meeting notes, the school was not found to have failed to have due regards to the duty because the governing body had considered relevant issues in substance and in the context of the school. Now, of course, this judgment doesn't bind other schools because it's fact specific, but it is a useful judgment when authorities are considering policies and equalities, not just in school, but within their local authorities as well. And on that note, you can read more on the items discussed today and many more besides by going to bulletin number 16, available on the LLG website now. So it's goodbye from me.
And from me too.